deposit. Deposit when there's an object deposited to another person for safekeeping or for security purposes. That's what you call contract of deposit. This is often practiced by malls or supermarkets. Before you enter into the supermarket or the mall, then you have a package or a bag. For security reasons, you have to leave them. No? That is contract of deposit. Another contract is donation, also gratuitous. Without any payment, a person gives a property to you or to another person who is the donee. The giver is the donor. So contract to sell is a contract of agency. Contract of carriage, what is this? So when you are hailing a taxi cab and you agree, the driver and you agree to transport you. I mean, the driver agrees to transport you or to take you to the place where you want to go. So that's contract of carriage, you know? Or if you want to go to SM and you ride a jeepney, so there is a contract of carriage between you and the driver of the jeepney. Or if you want to take an airplane going to Manila, you buy a ticket, so that ticket purchase and you will fly to Manila, that's a contract of carriage. Same as boat, okay? Another contract is contract of employment. This is a remuneratory contract, you know? It's a service contract, like carriage. This is a service contract or remuneratory contract. Then we have articles of partnership and articles of corporation. So if you agree with your friends to have a partnership, that's a contract. Or with a or to form a corporation, that's another contract. So these are examples of contracts. Again, you should know what are nominate and what are innominate contracts. So what are the principal characteristics of a contract? So number one, there is autonomy of wills. So what is autonomy? Autonomy is the freedom, no? So here, the contracting parties have the freedom to establish any stipulations or provisions or clauses or terms and conditions, so long as they are not contrary to law, morals, good customs, public order, or public policy. Okay, so there's autonomy of wills. So the parties can agree any provisions or stipulations or clauses or terms and conditions. Number two, mutuality. So there's mutuality between the contracting parties. So the contract must bind both contracting parties. Its validity or compliance cannot be left to the will of one of them. So the other party cannot compel the other person, or cannot the validity or compliance, meaning you cannot, one party cannot compel the other party to do what his will would want or what he wants, no? So there must be agreement between both of them. Okay? So if like for example, if you want to go to SM and then the taxi driver will say, okay, how about package deal for 200 pesos, and you will not agree. So there's no mutuality of contract. You will not agree because you want to use the taxi meter. Why you don't want to use the taxi meter? So there's no mutuality of contract. in that case. Now, the third principal characteristic is the obligatory force, meaning the contracting parties are bound from the moment there is already perfection of the contract. So meaning if there's agreement already, both parties are already bound. And not only for fulfilling what has been expressly agreed upon, but also taking responsibility to all the consequences after doing their respective actions. No? So the fourth characteristic is there is a protection of creditor. I just included this one. Now the creditors are protected in contracts which are intended to defraud them. So defraud is something like deceiving, or deceit. So if a contract has the intention of defrauding the creditors of the parties, then the creditors, even though they are not a party to the contract, has the right to rescind the contract. So another characteristic is relativity of contracts. So what is relativity? Now in contracts, it means that the contracts only take effect between the parties, meaning only the parties, the seller or the buyer. They're assigns. So if you remember, assign is transfer. So it's the same as transferee. And they're heirs. No? Of course, these are with exception. So you know what are heirs? So the successors. No? If the person dies, then whoever succeeds him, like his wife or son or children, they are called heirs. And this is found in Article 1311. Now here it states that relativity has exceptions. Now again, relativity is that principle which states that contracts take effect only between the parties, their assigns and heirs. So what are the exceptions? So here are the exceptions to the relativity principle. Number one, when the subject of the contract involves intransmissible rights or rights. No? So these are rights which cannot be transmitted to another. So if what is an example of this? A contract of agency. No? The contract of agency is one authorizes another to do something. No? Like for example, contract to sell. So I want you to sell my house, for instance. So if the seller or the owner of the property dies, then that right, or it's not the owner, the agent. If the agent dies, the right cannot be transmitted to his heirs or assigns, no, because he's the broker or the seller. He cannot transmit his license to his son. He cannot transmit his license to his assignee. So in this case, relativity principle does not take place, no, because the right is intransmissible. Okay. So contract of agency where the agent dies. So in that case, it cannot be transmitted. Number two, contracts creating real rights. So you know what is real right, diba? So if a contract creates real right, like mortgage, so another party is already bound if such right has been registered. So if the bank, let's say for example, has taken a real property as security of the loan, there's a mortgage, the bank will should register the mortgage with the register of deeds. No? What do you mean by that? So the property's title should have an annotation that this property is already mortgaged to the bank. So therefore, if a third person comes to the picture because he wants to buy the property and he reads that notation in the title that there is already a mortgage, so the bank is protected. No? So that's number 2. Number 3, contracts intended to defraud creditors. So I've explained this a while ago that if ever the contract between two persons involves or has the intention to prejudice the rights of the creditor, then the creditor may rescind the contracts, even if they are not a party to the contract. No? Rescind is similar as cancel or annul. This is the verb form and the noun is rescission. We have discussed that in obligation already. So I'll give you an example. Let's say a person, Mr. Juan, is indebted to Banco de Oro for 10 million pesos. And Banco de Oro knows that he has a property somewhere in Cebu City. Now, he has not been paying his loan to Banco de Oro, Mr. Juan. So, Juan knows that Banco de Oro is going to foreclose or not foreclose, but attach his property whenever they will file a claim against Juan. No? So, if the Banco de Oro will file a claim against Juan in the bank, then that property will be attached, meaning if they will succeed in the case, then they can get that property of Juan. So in order for the bank not to get the property of Juan now makes a simulated or fraudulent contract with another person that he is selling the property to him, no? Without any payment. So walay bayad. So, why? So the intention is to prejudice the right of the bank. So what do you mean by prejudice? Prejudice is to endanger or to violate, no, the right of the bank. So that's an example of number 3. So in that case, the sale between Juan and the buyer can be rescinded or canceled by Banco de Oro because it's intended to defraud the bank.